to one and all. Welcome to the webinar on intellectual property rights. I take this opportunity to welcome today's speaker, Dr. Abhinandan Patil, an expert in pharmaceutical sciences. Dr. Abhinandan Patil is a professor at School of Pharmaceutical Sciences at Sanjay Godavat University, Kolhapur. Startup hero of Maharashtra State Startup India under Make in India scheme 2018-2019. Sir has completed his M.Pharm in Shivaji University, Kolhapur in September 2013 and as a gold medalist with 72.82%. He further continued with his PhD in D.Y. Patil University, Kolhapur, PST, in August 2019, again awarded as a gold medalist. Some of his innovations and projects are as follows. 21 patent granted, 10 applied including international patent, 25 international publication, 5 book chapter, 1 review. Sir has experience in following colleges. Assistant professor for 2.7 years in Varnanagar, TKCP. Lecturer at TKIT Biotechnology Department for a year in Varnanagar. Principal for 2 months in Janta Senior Arts, Science and Commerce College, Hupari. A tutor at D.Y. Patil University Department of Pharmacology, Kolhapur. Assistant professor at School of Pharmaceutical Sciences in Sanjay Godavat University, Kolhapur. Professor at School of Pharmaceutical Sciences, Sanjay Godavat University, Kolhapur. World record hat-trick university topper in graduation, post-graduation, and PhD with gold medal in continuous succession in medical profession received from India's Book of Record and International Book of World Record. Life member of Indian Pharmaceutical Association. It is an honor and privilege for us, sir, to have you with us today. I also welcome principal of a college, vice principal, teachers, and all the students present for today's webinar. I am sure we'll be enriched by the session. Once again, I welcome all of you for today's webinar. I now hand over the session to Sir. Over to you, sir.
Thank you for giving the brief outlook related to my profile. I first of all want to thank Rohini Patil ma'am for giving an opportunity to share some of the ideas related to the intellectual property rights to all of you, especially the students. I want to thank the principal and all the teaching staff who are just here being the part in this session. So first of all, I request all the delegates to just mute your mic so that we can have the efficient way of the communication, and it is rather like a discussion so that whatever the queries you are having, we can have it over here, and we'll try to get maximum amount of the knowledge related to the IPR. So I'm going to share the slides over here. I hope that this slide is visible to all. Yes, is the slide visible to all?
Yes, sir. Yes.
So here you can see one small cartoon is there. I think it is long back ago when uh, we can say like in ancient times, where the first time the discovery of the fire was done by our ancestral human beings. So one funny quote is there that suppose if I invented a fire, maybe I may be the first inventor, but many people nowadays they are using without my permission. So this is like a kind of a joke. But currently, if you see the scenario, many inventions are coming into the market, and it is in the right time that we have to protect these inventions from the different society people, basically from the industrial persons, in order to keep that patent or IPR with you in order to get some royalty and to get some benefits. So this is a simple cartoon. So we'll see in detail that what exactly is the IPR, what we can call it as an intellectual property right. In that, what are the subsections? So before that, I want to share that if you want any kind of updates related to the research, you can just go to the website, that is abhiguru.com, where you can see a number of ideas related to the students' development, then some study habits, learning perspectives from the different countries, how you can make the things, and also one important package is there which is related to the music therapy. This will help the students. So we'll see in details that what exactly we are going to know related to this intellectual property right. So when we talk about the intellectual property right, IP, so most of the time we understand the terminologies like patent, trademark, copyright. Okay, but when we go in detail, this IP, that is intellectual property right, it includes n number of the sub points, which includes patents, trademark, copyright, trade secrets, geographical indications, and design. Now the question that comes in the mind that whether this intellectual property right or rights which are there, so how they are protected in worldwide scenario. So when we talk about our country or some other countries like USA, UK, Chicago, so they have their own individual firms which give the protection to whatever the intellectual property they are just coming up. It may be individual, it may be a firm, it may be industry, it may be any of the university department. So all these are like been protected by the n number of the agencies. Intellectual property is a property that arises from the human intellectual. Okay, so what exactly mean by the intellectual property? It means suppose if you come up with some any kind of invention, so these inventions is needed to be protected, and these protections are been categorized into various forms, as I mentioned priorly. So it may be like literature, it may be the artistic work, it may be the industry property. So we're going to go in detail and we'll learn that what exactly these properties are. So first upon, we'll talk something related to the patent. For every individual who just come up with some idea, which is having some kind of an application, so they can go for like a part which is called as a patent. Patent, it is a very important aspect where whatever the discovery that you are doing and which is having the benefits to the humankind, so that can be protected. And this protection, it is given to the inventor in such a way that that inventor will decide that who should execute, use this discovery in order to make benefit to the mankind, and on opposite side they can get the benefits in the form of the royalty. Royalty, it means their inventions is protected, and along with that they get some handsome money, and this money will be like given for the period of 20 years when we talk about the patent. So that part I'm going to go and discuss with you in detail later on. So first of all, I will give you the brief outs that what exactly different IPRs are there. Then there is another part which is called as a design. So it is an industrial based concept where the outer shape or the configuration. So these parts are protected, and accordingly the benefits are given to you. Next, that is a trademark. So trademark may include the brand name or the logos, which may be like denoted by the R. R means it is a registered trademark. So that part I'm going to show you in the further slides. Next, another part is there a trade secret. The client may have some special formulas. Okay. For example, you know the flavor of a Coca-Cola. So whatever the taste that you just uh, observe, the essence that you get of the Coca-Cola, same essence you will not get from the different types of brand, okay, which are there in the marketed. Even some of the people, they visit some cold drink shops and they get some cola flavored soda. So if you see that cola flavored soda and if you try to compare it with the Coca Cola, then the difference that you're going to see is that the whatever the taste is there, like 10 years before or prior to that, or in the coming days, whatever the taste will be there, it will remain intact, it will be remain same. And that is the secret, and that secret formula, it is known only to the product owner. Coca-Cola is just one of the example. In the similar way, there are a number of the formulations which are present in the market. It may be the ice creams, some foodstuffs. So all these are been protected by the concept which is called as a trade secret. Next important part, that is a copyright. You might be seeing that, you might be watching some movies, you might be seeing some music on different platforms. So these are been protected by the concept which is called as a copyright. Now one example I just want to show in the further slides, that suppose if you are watching some movies on the YouTube, you know that suppose if some person if try to copy that part, and if he try to present by his name on that online platform, indirectly there comes a concept which is called copyright strike. Copyright strike means what? You don't have an authority to copy the music, art, some literature from the person who has been copyrighted it from the government agency without the prior permission. If you are doing so, then there are certain legal issues that you may face. So that part also I'm going to share you in the further slide. So this is the IPR in short, that industrial design. So if you see, this is a Coca-Cola bottle. So whatever the design which is there, so it has been confide, okay, or it has been like with the company itself, that is a Coca-Cola. Then some patents are there which may include some medicines, some discovery of some uh, products or some machineries that you have been devised which showing some good activity. So that part is also comes under the part that is a patent. Trademark or trade service, so this is the trademark, one of the example, that is a Coca-Cola. So how they are designed, so these cannot be copied by any of the person. Then trade secrets, as I mentioned you, that secret agents, that flavors are there, or some output oriented things are there, especially with the industries of food or some drugs, so that it is like a trade secret. Geographical indications, one of the good example, you know that orange. So when we talk about the orange, so which place comes in your mind? Anyone? Is my voice audible, by the way, because I'm not getting any replies from the students? Hello.
Yes, audible, sir. You are
Yeah, so when we talk about the orange, so what comes in your
audible.
mind? Orange. Orange, it is peculiarly available in which part of our country? Is it Kolhapur? It is Delhi, or which other place? Yes, anyone?
Nagpur.
Yeah, it is Nagpur. So that means that geographical area, it is given an authority that if we talk about the orange, then that right, it reserves basically to that area. And that's why this is nothing but we can call it as a geographical indication. On the similar grounds, there are many other IPR parts, that is the layouts or designs of some semiconductor circuits. Okay, these circuits are very important because nowadays, if you see whatever that new gadgets are coming into the markets, so these gadgets are equipped with n number of things, and these are been designed by using some integrated circuits and all that. So that specific designs are also comes under the part that is called as an IPR. Even some plant varieties, or there are certain farmer rights, so it depends upon genetical modulations. So there are certain legal aspects, some rules and regulations are there. So these parts are totally like industrial or commercial point of view. And geographical indication also, it is related to some area where the specific parts are there. For example, if you talk about Banarasi sari, so it as the name indicates that the sari, it is from Banaras, so that it is like good example that geographical area plays an important role. So today we are going to talk in detail some other points which like how these patents or how the different governing agencies are playing an important role. So one of the good example is the WIPO, that is a World Intellectual Property Organization, which come into the inception in 1967. So this, it is the specialized agency of United Nations which promotes or protects the different types of the IP, that is intellectual property right, that I have just mentioned you. And basically, when we talk about the WIPO, its headquarters, it is located in Geneva, that is in the Switzerland. So based upon that, we are celebrating the World Intellectual Property Right Day every year in the April 26th, with a vision that each and every individual will come up with their own ideas, and based upon that, they can have their own intellectual properties. So as I mentioned you that there are different types of books, paintings, musical compositions are there, some movies are there, programs are there, performs are there. So all these have been protected by different types of the intellectual property rights. So this can be protected by the like copyright. So in the on that basis, as I mentioned you that there are different types of protection. So we'll go in detail and we'll know that which are the different acts that are protecting our different intellectual properties. So when we talk about the functional and technical inventions, so these are protected by the Patent Act, which is currently uh, updated in 2005. Similarly, when we talk about some artistic work, some literature, some studies, or some inventions that you have done by on the paperwork, so that has been protected by the copyright. So updated version, it is available in 1999. Some slogans, some symbols, logos, words, sounds, color, or some designs are there, so that are being protected by the part that is called as a trademark. Currently you might be seeing that one company that is a boat, okay, they have launched some earpod. So when we insert the earpod, then it gives the sound that is power on. So that means that whatever the sound that has been created, so specifically it is with the boat company. So that means this boat company, they have just applied for the trademark, they have granted with it, and that is why people nowadays they are favoring these types of the product. So these all part which the company enhancing its product, they are reaching to the society, and based upon that the community is enjoying their product benefits. So all these have been protected in the part that is called intellectual properties. Patents. So it is discovered under the act, first of all come into the existence in our country in 1970. So whatever the part is there related to the patent, it is protected by the central government agencies, and it has been officially gadget that anyone who has been discovering some parts which may include some novel useful things, okay, some subjectual parts or some non-obvious things, so all these comes under the patent. I'm going to discuss that what exactly things are there that we can patent. So this can be related to some process, some product, or the both. For example, suppose you have some machineries which extract the juice. Suppose priorly the extraction carried out by the previous machine, it gives the juice of concentration 80%. But suppose if you come up with some new machine which is extracting and bringing the product in with the concentration like more than 90% or 100%, then definitely it is a good invention. That means you are saving the time, along with that you are increasing the concentration. So all this part, it comes under the invention, or it can be considered as a process or product. Second, an inventive step, like escalators are there nowadays. Instead of like stairs, we are using the escalator. Or instead of that, suppose if you are coming up with some new steps where it is reducing the power, it reducing the money, or it is reducing the time period, so all these innovative steps can be patented. Even it is capable of like having some industrial applications, or even a machine, okay, because priorly if you see, like earlier we in 90s we were having the mobile phone with a big like heavy stand, and that was a bit heavy, and it was like not compatible for using. But nowadays we have smartphone, and in coming days a number of new developmental part is taking place. All these things, it is nothing but we can call it as a machine or some gadgets. One of the example that is we are having smart watches. The smart watches, it is giving you the time, it is giving you all the details. So all these are been like a machine which is giving the comfort to the human being. So these are also like protected, and this comes under the patent. So life and duration, as I mentioned to you that these patents, these are protected for the period of 20 years from the day of the filing. So the suppose if you discovered something and if you are like wanted to bring it to the market, so that royalty will be with you for the period of 20 years. After 20 years, it will be like be open to the public. So anyone can just formulate the same part and they can bring into the market. So that means you can enjoy the royalty up to the period of 20 years. Now, when we talk about the patents, there are different types like utility patents, plant patent, and design patent. Utility patent, as I mentioned to, it may be like any machine, its process or composition. So that comes under the part which is called utility patent. Plant patent, when whoever invents or discovers any type of like asexually producing new hybrids, okay, which may have like fast growing abilities or some different taste. So these comes under the category which is called plant patent. No bacteria or similar singular single cell organisms are needed to be applied, because these cannot be like considered for the patenting. Only new discoveries, some hybrid strains are there which can have some different activities, so that part can be considered as an plant patent. Design patent, as I mentioned you, that suppose if you bring some new design, it like some shapes are there, some ornamental designs are there, which may include the part of jewelry, some machinery, some designs which make you comfort, okay, which make you comfort, so that can be considered into the category which is called design patent. And it can be easily designed around, and no functionality is required, because suppose if you create some design, so there is no need to give the description, because whatever that design is there itself, it is innovative and it is showing some benefits. So based upon that, these categories patents which are applied are considered under the domain which is called as a design patent. So under the Indian patent law, a patentable invention should be a new product, a new process, non-obvious, it should be useful and capable of industrial application. So that means a new product itself, a new process. Non-obvious means, I will just discuss that part in the further slide, what exactly mean by non-obvious. So non-obvious means it's the invention must be non-obvious to a person skilled in the art to which the invention relates. It means that priorly no one was using this technique. Suppose if anyone is using the ancestral process and if he comes up with the concept that yes, this is my invention, so that part cannot be patented. That means it should be non-obvious. It should not be obvious. Usefulness, it means it should have like benefits to the mankind. So underline the statement, anything which is giving the benefit to the human being, that can be patented. So there are certain exceptions also, like inventions which are injurious to the public health, that cannot be patented. New methods of agriculture cannot be patented, because if it is related to agriculture, it should reach to each and every farmer, so that is the agenda. So for that purpose, these inventions cannot be patented. A process of treatment of human beings, animals or plants, they cannot be patented, because if it is directly related to human being, animals and plants, they are not patented. So we'll go in detail that what exactly cannot be patented. So it may be like computer programs, it may be some medical or surgical treatments, mathematical methods, business methods, some discoveries like discovering some new organisms or some new animals. Okay, accidentally if you're coming across some new specimens, so they cannot be patented. Aesthetic creations, okay, which having some essence and more benefit to the mankind, so that cannot be patented. New species and plant, as I mentioned you. Then inventions which are contrary, that is contrary to moral standards and public orders, for example like atomic energy, some bombs, some weapons, so these cannot be patented, so they just bypass the concept that is called as a patent. So similarly, in the same manner, some circuits are there, they cannot be patented, some literatures and all. So there are certain conditions, and whatever that the list I have provided, so these things are not patented. So persons which can entitled to the apply for the patent. So the person should like be the first inventor, then he can go for the patent. Any persons being the assign of the true or first invention of the invention, they can also go for the patenting. For example, if you are the working in the any industry, if you are working in any university, then yes, you are the discoverer. Then you can assign the authority to the university that yes, you can go for the patenting, and you will be the first inventor by the legal representative of a deceased person who immediately before date was entitled to make such an application. For example, suppose if any person has discovered some part, and by default, suppose if he give the power of attorney to any of the individual, then definitely that authority who has taken the power, he can also go for the patenting after the death of that person. So there are like full disclosure of an invention. That means when we go for patenting, all the details that what exactly you're protecting, what it exactly contains, so all that draft you prepare, it gets submitted to the patent agency. Once it get submitted, they just go for scrutiny. Based upon scrutiny, if it is having some like good inventional part, then it is published. And once it is published, then there is a grace period like 6 months to 1 year, where the that literature it is like made available to the public, where suppose if anyone comes and claims that whatever the discovery it is mentioned we are using, then it is not patented. And if no one claims that yes, this part is purely inventional, then definitely the patent which is there, it is granted to you. If you see, if you don't see a problem with this question, you need the class. Definitely, you can read there that all I asked was, can I patent my copyrighted trademark? So just write it down and just tell me what exactly the joke you see over here. Okay, at the end of the session, I will just share with you. So again, read this. All I asked was, can I patent my copyrighted trademark? So it is a funny quote. So just let me know that you understand what exactly it is. So if you talk about the jurisdiction area where we can go for the patenting, so they are available in the local areas like Mumbai, Chennai, New Delhi, Kolkata. So these are the branches where you can just apply for the patents. So the life cycle of the patents, if you talk, so it includes the filing of patent, then examinations will be conducted, then it go for the publication. Once the publication is there, then will be like search and substantive examination. And if there is like purity on the claims that you are giving, that yes, these inventions are mine, then based upon that you are granted, and the publication is then, that is called final publication and grant of the patent. So, basic requirement for patentee, as I mentioned, it should be have proper novelty, utility, non-obviousness, and written disclosure. So there are different forms, like for application forms are there. Form 1. There are some other specification which is called Form 2, where we can apply for provisional or complete specification. You can go for drawings, understanding some undertakings are there, that is mutually based upon some, like with firms or individually you have a group and all. And power of authority, it is given by an individual to some other person, some industry, or to some agencies, or rather it can be given to the patent attorney. Suppose if you are not having the knowledge how to write the patent, you can give the power of attorney to the that person who is writing the patent, and based upon that the patent can be granted. So what does patent system do? It encourages the research, it helps the inventors to disclose his invention, it helps to establish new industries, and definitely these industries have the good commercialization values. It facilitates the technology transfer. So whatever the discovery you are doing, definitely it is called as a technology transfer. That means from lab to the industrial scale. It stimulates your research in your universities, in departments, and it acts as a catalyst where the new discoveries that you are doing, so they are like having the potential to create new businesses. So compulsory, this license is, that means after a time when the patent is there with you, you can provide the regional, there's a reasonable requirement of the patent to meet the public standards, and based upon that you can get the different benefits. So this license of the patents, it belongs to you, and based upon that you get handsome amount royalty or the different benefits. Infringement. Now what exactly mean by infringement? It means, suppose if the patent that you have discovered, and if someone without your knowledge is trying to make the duplicate copy, then based upon that you have the authority to file a case against that person. And there are different types. They're like direct and indirect. So what exactly direct and indirect, I will share you later on, but just try to understand whatever the patent that you are granted. Once the patent is granted, if someone tries to copy the invention that you private, indirectly you can file a case against that person, and the government will play an important role to protect your rights. The consequences of the infringement is, suppose if someone tried to copy your patent, then what happens, that injunction, which means that all your product may be removed from the market. Okay, suppose if you are trying to copy some inventions of some person who has just patented, in that case your product will be withdrawn from the market. There will be destruction of your product. You have to pay the damages that has occurred to the patent owner. And maybe suppose if you are copying some person's patent, or suppose if someone is copying your patent, then he may be imprisoned, he may be sent to the jail also. So these are the consequences of the infringement. That means how the government is protecting your intellectual property. So there are different types of the patents, like it may be the drug component, some formulations, some synergistic combinations are also been protected. For example, A and B do two drugs, when they are brought into the combination, they are showing the effects in the 10 times effect. So that is called synergistic combination. Some technology can be patented, some polymorphs are there that can be patented, some biotechnology products are there. Suppose one of the example, you discovered some microorganisms, and that is showing some good effect. So that part, which may be the like a food, or it may be like a drug, all these process can be protected. Even if you come up with some machine which is showing some good results, so that can be protected under the category which is called process patent. So these are different examples, like how these tablets are there, or some formulas are there. So these all are been protected by the patent. So patent holder, if we talk about the list of top 10 patent holders in the Indian comprises, so these are pharmaceutical and biotechnology companies. So in India, 184 patents are held by the Council of Scientific and Industry Research part, that is called CSIR, which is followed by Ranbaxy company. So many IT industries are also there, which are having their own patents, and across the world, no IT firms currently they have like been applied for the patent. But globally, what has happened, some foreign agency they are coming, and in group they are patenting, and the count is increasing. Because if we talk 20 to 30 years back, at that time India was not in the list of the patent. Now if you talk, India is in top 5 patent holding countries. So USA, China, so these are the top. But we are lucky enough that our discoveries are now come into the accountability, and India ranks in within first 5 patent holding countries. So this is the youngest patent holder person. He's a 6 years old child who has discovered some chessboard where multiple people can play the game. So it comes under the category which is called design patent. So this guy, he holds the title of youngest patent holding. This is how the patent generally looks like of different countries. So this is of UK, this is of United States, and this is the literature, how that literature comes, like some abstracts are there, some claims are, so that part is totally different. So some another day I will discuss you that what exactly it contains in detail, because it is a very big topic. Next we will talk something related to the part that is called trademark. It was discovered in the act sorry, it was came into the existence in the act that is 1990, and currently it has been replaced with a number of changes. So the trademark, I'll just go with the part where exactly it's there. Just a second. So this is the trademark. So it may be the name, it may be the logo, it may be the symbol. Okay. So M, it is a symbol for McDonald, you know that. Slogan may be there like I am loving it. So they can be anything. It may be the shape and even the color. So these are the different perspectives of the trademark. So anything that is attracting the attention of the public, where your product profile is enhanced, so that can be considered under the another part of the IP, which is called as a trademark. So when we talk about the trademark, so there are different procedures like application for the search, then application for the registration, then examination, then advertisement and filing of opposition and certification. So this is the procedure that how we can go for trademark. Suppose if you want to create your own trademark, so first of all, the government agency will search whether you have copied it from some agencies globally. Then there you have to apply for the application. There will be like examinations. Then once the examination is conducted successfully, they give the advertisement that yes, that this is the new trademark, and if anyone have the objection, they can file for the objection. If there is no any objection, at the end the certificate is issued. The trademark is valid for 10 years from the date of application, which may be renewed after 10 years. That means every 10 years you have to apply for the trademark, and for that purpose you have to pay some government fees. So the government fees for the trademarks, it has like 2,500 rupees is there, which is the government fees. And further, there are some agencies like patent attorney or some trademark attorneys are there. They take some other amount for the filing, and based upon that you get the services. The applicability of the trademark, it is related to in connection with the marketing of your goods and services. So suppose if you are coming up with some catchy trademark, then definitely by that name, by that signs, by their slogan, people will understand that yes, this is the product of that company. Just see, these are the different trademarks. And how the people they are misusing. So suppose this is a Vimal. So some people they are making some other name, okay, and trying to like fake the original company. Even if you visit like some public places, So you will be getting shocked that like some products like Nike is there. Instead of Nike, they can say as a Nike. So that means they're changing the name. So their pronunciations is changed in such a way that people will not understand whether it is like copied or it is like it is original. So that means these types of things are happening currently. Next important part that we are going to talk, that is a copyright. So copyright rules are changed from 1982 and now it is updated till 1999, and even 2003 also, or 13 is also there, where some updations are there. It is a right which grants to protect the unique expression of ideas. Suppose if you're writing some poems, if you're writing some kind of literature, you are writing some stories, or even you are writing some new formulas. So all these are protected under the umbrella which is called copyright, because these part cannot be patented, because it is a literature, it is a movie, so we can't go for the patent. So for that purpose, these are been protected under the Act, which is called copyright, which may be like original script which is written by an author. It may be there is no requirement for novelty or uniqueness, as there is a because that is not the like part of an patent law. The copyright law protects the expression of idea. Whatever you express on the paper, in the movies, in the literature, all these are protected under the part which is called copyright. So these may be like literature, it may be film, drama, sound recording, books are there, music is there. So all these are protected under the act which is called Copyright Act. So the registration of a copyright is very simple. You have to just fill up some application form. You have to pay some fees. There is no need to send a copy of your work. Only the brief idea you have to give it. Once it is like submitted, it will be like interpreted. It will be checked independently that whether it is the original part or it is like some copied from some agencies. Based upon that investigation, you will be receiving the certificate on which there will be mentioned your name, your affiliation, and the data that you have copyrighted with the certification from the government. The copyright lasts for lifetime, that is 50 plus years. Okay, from the end of the calendar year in which the author dies, then 50 years from the films and sound recording, 25 years for the topological arrangement of the published edition, and this copyright protection also expires on December of 31st of December of the last calendar year of the protection. So this copyrighted, it has great protection, because when we talk about patent, it is for 20 years. Copyright, it will be like for the lifetime, or even after the death of the person, 50 plus year, this protection will extend. And it expires that means at the last date, that is on 31st of December. It gives the permission, that means what is the fair use? So it gives you the permission to use the copyrighted material if certain criteria are met, like protect freedom of speech, protect that is promotes public benefits like education. So suppose if your document is protected, then you can give the authorities to the person like industries or some research agencies, and based upon that you can give the your authorities that yes, you can use my copyrighted based upon that some handsome money or the some royalties are to be given to the owner. So if this royalties is given, so based upon that you will get the benefits. So be aware the fair use or the excuse. Never assure that you use falls under the fair use exception, because if you are using some like YouTube also, you will see some musics are there. So they are being protected. And if you try to copy that music, and if you try to use it for your own documentary part, then indirectly the YouTube also gives you the strike, that copyright strike. And this means it is like giving you the warning that don't copy that material. Even sometimes if you try to see some some funny comedy shows also, in that also, whenever there is a music, you may see that that music, it is muted and there is a mention that this is a copyrighted part, so the music will not be played, and later on that show get continued. So that means at a global platform also, many parts are also protected. So saving money is not the sufficient excuses. Laziness can be a trap. That means if you're trying to copy some material without the prior indication of that owner, indirectly the copyright will play. Even suppose if some pictures are there, some documentary, some research is there, And if you're trying to use it in your research, in PhD work, in your project also, without the prior knowledge of that owner, indirectly, suppose if you are getting caught, then there will be n number of consequences. As I told you, that there may be a case filed against you, you may have to give the penalty, and even there will be like imprisonment. How much I can use? Suppose if you want to use some photos and images, up to 5 works that is from author, or up to 10% or 15% of the work you can just use it from the collection. That means it can be considered as a plagiarism. Plagiarism is the part that means you are copying some content, but with the aim that you are not misusing it. You are giving some references. So definitely up to 10% you can copy some data, images, not 100% from the author. The database information, up to 10% or 2500 fields or cell entries you can copy. You can use it as a reference, because if you try to write some research, definitely you have to include some part that yes, this part was discovered by some person. You can acknowledge that person, and up to 10% you can use the data, and based upon that you can highlight it in your research. Now we'll talk something about that how the actions are taken, which is called infringement. Infringement, what? You're copying, which is very dangerous part. So what constitute infringement? Any reproduction, use, distribution, performance of the work without the permission of owner, it is called as an infringement. I request the delegates to keep your microphone off, because it is creating a disturbance. Dear students, just keep your microphone off, because it is creating a disturbance.
Sir, continue. Hello, sir. You are not audible.
Okay.
Sir, you are not audible.
Yes, ma'am. Is currently my voice audible? Just check.
Yeah, yes, sir. Now you audible.
Okay. So that means you cannot copy someone material, you cannot redistribute it, you cannot use that data without a prior knowledge. And if suppose if you're trying to make a duplicate copy of same materials, then definitely it comes under the part which is called infringement. Infringement means you are copying and you have to face the damages. Sorry, you are damaging the profile of some persons, or some injunctions is there. In that case, the company, the individual, the university can file the case against the person who is copying that part. So a suit can lie in the district or in the high court. That means the government itself is protecting you. Okay, suppose if you come across some companies who, without your prior knowledge, are using your ideas, so definitely the suit can be there in the district or in the high court. And in that case, it may issue an injunction which either to prevent the infringer from further use and avoid damages to the patent owner, or pay the patent owner the royalties for the further use. So there are three conditions. Suppose if someone is copying your idea, you can do three things. First of all, whatever the profit that person has earned during this tenure without your prior knowledge, you can just ask for that money. Second one, you can suit a case against him. Or third one, instead of going for disputes, you can say that yes, you can continue with the part, only you can say that, yeah, please give me the royalty for that whatever the product that you are selling into the market. So there are different remedial part for the patent infringements. So Apple has sued the HTC over iPhone patent because Apple has sued the phone maker HTC and has filed a complaint with the US International Trade Commission alleging that the Taiwanese companies is infringing 20 Apple patent related to the iPhones. That means whatever that iPhone was having their own device or their own different systems were there, so that was copied by HTC. So that company, Apple, that is owner is Steve Jobs, he's given the statement that we think competition is healthy, but competitors should create their own original technology and not to steal their ours. That means HTC company was filed with the infringement, and they have to pay heavy amount to the Apple company because they have copied some apps which were purely related to the Apple. So the remedies, a suit can lie into the district, and same case as I mentioned, there can be the punishment which may be from 6 months to 3 years, and the permanent bans will be there on the commercial activities of the company. Indirectly, suppose if you come across an idea that suppose if XYZ mobile company, if they are copying some material, and if there is a bad publicity, indirectly what happens, you know that customers are very intelligent, they stop using the product. So there is heavy competition in the market, so that should not happen. So for the trademark also same laws are there, and they may extend from 6 months to the 3 years, is as like same like your patent. Examples of successful civil actions, that is, three suits were filed by the Adidas in the Delhi High Court against the counterfeiters. Okay, so Adidas, you know the company, they have filed a case against some local vendors where they were using the same name as an Adidas, and because of that, the an initial stage infringing goods were seized by the local commissioner, and 15 lakh was given to the company owner, that is Adidas Solomon. You know that some duplicate product markets are coming, duplicate products are coming into the market with the name that is a first copy. You might be knowing that part. And if they are copying as it is, for example, the spelling of Adidas is Adidas. Okay, and if someone is copying as it is, then definitely there is a case. But to prevent that part, many people what they are doing, they say that's ADUDAS. It spells like Adudas, but jaldi mein kya ho jata hai? We spell like it is a company or like of Adidas, and we purchase the product at cheaper cost. So that means you also have to check as a customer that whatever the product it is coming into the market, whether they are original or their first copy. So same case is there with the copyright also. If someone try to copy some material without the prior knowledge, some music and all that, so there will be case according to the Act of 1957, and there will be jail or imprisonment for the period of 3 years. So that means a very big risk is there. And at the end, what happened? The name of the person or the company or the university, it get blacklisted. So that is a big issue. So that means do not copy anyone's material without the prior knowledge. Some copyrighted claims on the basis of underlying artistic work you can see here. That is a Ritika company versus with Ashwin Kumar. Okay, so these are the different copyright claims are there. So they are like copying the same material without the prior permissions. So many cases are there still running. So this is the one of the example of like clothes between two companies, that is a Ritika versus Ashwini. Okay, Ritika versus Nina, Ritika versus Mobin. So these are the many companies are there. So if duplicate things are coming into the market, so the case will be filed. But what I didn't know, suppose if you called like innocent infringement, which may occurs like infringer was unaware that things was protected, no excuse if work.
So you are not audible.
Hello, is my voice audible to all?
Sir, right now you're audible.
Hello.
Hi, yes, sir, you're audible. Hello? Hello, sir?
Hello.
Yes, sir.
Yeah, actually there was some internet issues. I'm just connecting from my mobile.
Okay, okay, sir.
Okay, so as I mentioned you that these laws are there, and these laws plays an important role in the case that suppose if you try to copy some data, some information, some products, if you try to make some duplicate copy of the machines, or rather if you try to do the things which are against the laws or against the prior knowledge of the owner, then definitely you have to face the consequences. And these consequences, it comes into different categories: for the patents, for the copyrights, for the trademarks, or some other indications. In these cases, many issues can come, like court, imprisonment, money, and many other parts. So this was the in general brief idea that how the intellectual property rights are protected, and how these intellectual property rights make you a good researcher. And along with that, the important part is that if you're trying to bring the product into the commercial perspectives, definitely your inventions will be considered and you will get the royalty. So this was the in general idea related to the patent, intellectual property rights, and their different rules and regulations. So I just will call all the students to just have will have a good discussion over here related to your queries. And based upon that, suppose if you have any queries, I am happy to give the answer to it. So it is open to you all.
Students are requested to ask questions if you have any.
Okay, hope so you understand the difference between